Welcome back to another video. Today we're talking about civil litigation and things that you should do pre-issue. I'm Daniel Shen-Smith, I'm a barrister of England and Wales. If this is your first time here, please do hit the subscribe button and the bell icon so that you get new videos. So today's topic is the very broad area of civil litigation and essential things that you should do pre-issue. That is, before you issue your claim at court. Because until you issue the claim at court, it is not a live claim, it is just a dispute between parties that is yet to go to court. When you do issue the claim at court, that sets the clock ticking and there are various timetables and deadlines that you must comply with as the claimant and the defendant or defendants must comply with in response to your claim. It's important to note that there are very often cost consequences for missing these deadlines, so before you issue a claim you should know exactly what you're doing so that you don't miss these deadlines and fall foul of any rules so that you get cost implications against you. So with that in mind, let's have a look at the things on my list that are essential that you should do pre-issue of a claim. The number one thing on my list is that you should seek advice. It sounds very obvious and straightforward, but you will be surprised how many prospective clients wander into a law firm and just insist on issuing the claim and getting straight to it without any of the prerequisites or taking any advice. But by taking formal advice, your lawyer will be able to answer, do you have a case? Surely this is the most fundamental question that you should be asking before taking someone to court. A proper advice should address the strengths of your case, the weaknesses of the case, what it is that you need to prove to be successful in your claim, and whether you have the evidence available in order to rely on that evidence to prove your claim. If not, what other evidence do you need? How will you gather that evidence? And how will it be reliable in the court's eyes? Are there any limitation issues? For example, most civil cases and contractual claims have a limit of 6 years. Personal injury has a limit of 3 years, all of which are subject to special rules. For example, with personal injury, although it is a limit of 3 years, it is either from when the incident happened or from when you had knowledge that the incident caused the injury, or if it was a minor, the limitation doesn't begin running until that person is 18 years old. Another obvious question that should be addressed in any advice is whether or not you are intending to bring the claim against the right defendant. There are lots of examples where the obvious defendant is not necessarily the correct one, but if you begin a claim without identifying the correct defendant, at best it's going to be a procedural hiccup because you will need to substitute the correct defendant, and you're going to need to overcome that in the process of litigation. Legal advice can come in many forms, and the more comprehensive the advice, the more expensive it's going to be. However, a more comprehensive advice is going to limit the risks of your litigation moving forward because it should identify the strengths and the weaknesses in your case so that you can be prepared for those during the course of litigation. You might opt to have advice in conference, either with your solicitor or your barrister, and this is generally talking through your case to try to piece together what happened and the essentials that would normally form any comprehensive advice. I would always recommend that you get a full written advice from a barrister who specialises in the area that you are intending to claim, so that it should deal in full with the things that I've mentioned and give you a realistic prospect of your case. Once you are comfortable with the advice that you've received, you should talk to the other side, and by this I generally mean you should write to them through your lawyer. That's because even if you've had telephone conversations or email exchanges with the other side about this dispute that you have, they usually won't take it quite so seriously unless they've had a letter from a lawyer inviting them to comment on the dispute and to see whether there is any scope for resolving the issues between you. Because after all, court should be a last resort, and you will have to demonstrate to the court that it has been a last resort and you've tried everything to settle them beforehand. Now, I don't just mean a letter of claim and pre-action protocols, that comes later. In many instances, you can resolve these things with a simple, very concise letter from a lawyer that puts the other side in the clear picture that you want to resolve things, and if you don't, court may be the only option. You should also be realistic about the scope and what you are able to negotiate. Don't go into a negotiation thinking that you want everything your way or it's going to court. If the matter is to resolve, both sides must give a little bit, because in the best negotiations, both sides either feel like they won or both sides feel like they lost. But usually, and in my experience, both sides have to give something so that they meet somewhere in the middle in order to resolve it without going to court. You should also think about whether you want to salvage the relationship with the other party. Very often there's been a dispute come about and I've been involved, but the parties wanted to salvage that relationship. Obviously, that is much less likely if it's already been to court. Both sides have spent a lot of money, and there is this adversarial sense between them. There's cost implications, and very unlikely that they want to do business after that. So if you want to salvage the relationship with the other party, and really think about that, don't just think about the dispute that you have at hand, think about the long term, think about the real ramifications. Is it a supplier to your business, for example, that you just can't live without? Or would word get around in the industry that you go around suing people and ruin your reputation? There are lots of things outside of the realm of litigation and suing somebody that you need to think of. It's the relationship with that party, your reputation in the industry, and so on. Then one step further on from that is the pre-action protocols. Most people will know this as a letter of claim, but certain claims have specific pre-action protocols that you must follow, otherwise there might be costs and sanctions implications for not following them. In most cases, this will be satisfied by a letter of claim, but again, any specific protocol should be picked up by your lawyer in the advice stage so that you know that you are going to follow these protocols properly in the event that you do push on to this stage. I have a separate video talking about the letter of claim, and no doubt I will do new videos on letters of claim in the future, but this letter of claim broadly will set out your position, why there's a dispute, why you want it resolved, what you think it would take to resolve it, and give the other side enough time, information, opportunity to respond to your complaint so that court really is a last resort and this letter is the final stage. Even then, let's say you followed all your pre-action protocols if there's any special ones, or you've sent a letter of claim and you think you are ready to issue your claim. But hold on, there are some strategic opportunities that you can take advantage of. Consider whether you've made any offers in the case. You may have made informal offers, you may have had mediation and made offers at mediation. All of these aside, you can make various types of offers at any stage and certainly before issuing proceedings. The most robust of these offers is called a Part 36 offer. It is an offer that is made in compliance with Part 36 of the Civil Procedure Rules. What makes it special is that there are significant cost consequences. If you make an offer under Part 36 that is compliant with the rules, your opponent rejects that offer, but then you get to court and you get a judgment which is at least as good as the offer that you made. That triggers several cost consequences which can be quite detrimental to your opponent. Part 36 offers can be made at any stage, including before proceedings. There are lots of rules and I will go into Part 36 offers in more detail in another video. Let's say that you've done all of that and you think you are ready to issue your claim. But again, hold on, because what about the costs moving forward? If you've had a lawyer involved by this stage, you may have paid for your initial consultations, you may have paid for some advice, you may have paid for some correspondence, you may have paid for top-up advice, you might have paid for investigatory work to be carried out. Then you've most likely paid for a compliant letter of claim to be sent, and perhaps they sent a reply, which you then paid your lawyer to consider. You may have taken further advice based upon their reply, all of which before you've issued your claim. So my highlight at this point is to forecast the full costs of running your litigation. You may be surprised that very few clients actually go through this process of forecasting the projected costs for the full litigation, what we call to trial, which means to judgment, all the way through the process of litigation, through to the trial, and right to the end for judgment. If you don't know what the full costs of the litigation are going to be, you may well run out of money halfway through and then be left on your own because the lawyer is very unlikely to continue working on your case for free if you run out of money. And it should go without saying that if you continue to run the case by yourself and your opponent is represented and you are not, that will hinder your chances of success because they will be better placed to argue the case against you. If you've done this calculation, you need to ask yourself, am I or is the company in a position to afford this full cost of running the full litigation? If not, you need to give serious thought as to whether you're going to issue the claim in the first place. And if not, there are some options you can consider, although they might be quite limited. You may find a company that's prepared to do the work on a no-win, no-fee, which means they only get paid if they win, and there are certain rules about that as well. You may get a lawyer that will do some of the work pro bono, although this is few and far between and usually reserved to cases with clients in the most desperate of situations. And then you may also consider litigation financing or litigation funding. Litigation financing is exactly what it sounds like. You are financing the litigation. In other words, you are borrowing money to fund your litigation. In which case, I come back to the advice and I would say it will be a huge mistake to finance litigation without knowing what the merits of the claim are. Litigation funding is very different, and again I'll come back to it in another video, but in brief, some companies known as litigation funders might consider funding your litigation in exchange for a percentage of the damages that you win at trial. A similar arrangement would be known as a damage-based agreement, but again, much more detail in another video. So hopefully you can see there is a lot more to think about than many people give credit before issuing your claim. I would suggest all of these things should be done in every case, however big or small, and it will be proportionate to the amount that you're claiming. And money isn't the only consideration in all of this, because if you're involved in litigation, it can be very stressful, it can take a lot of time out of your working day, and many people that embark on litigation wish they hadn't done so when they are halfway through. So if you are in the position of considering issuing a claim, I hope this was useful. If you are a law student and you want any more detail on any one of those sections, please drop me some comments underneath the video and I'll pick up on those in separate videos. Thank you for watching, and don't forget to subscribe and hit the bell icon and smash that like button if this video is useful for you. Thanks for watching.